sure you all know this, but I'm going to tell you anyway. The mere fact that a patient gets a bad outcome or a bad result does not mean that there's malpractice. And the patient doesn't understand that. When we tell them that, they don't recognize that if they truly believe that the doctor did something wrong. They say, no, I went into the hospital fine and now something happened, must have happened, and now I can't walk. Well, maybe, but then again, maybe not. But the moment you tell them that, they get all defensive. They say, what do you mean? Something must have happened. Maybe yes, maybe no. But the mere fact that they had an untoward result or not a perfect result does not mean necessarily that there's malpractice. All right. If somebody comes to you and says, the doctor didn't tell me that I could suffer all of these problems, I want to sue him for lack of informed consent. Why? Because had I known, had the doctor really told me what the risk was of getting this complication, I never, ever would have had this problem. You know what? I'm going to suggest to you one thing. In every type of case involving informed consent, lack of informed consent, here's what happens. The doctor always says, of course I told the patient what the risks were. The patient almost always says, the doctor didn't tell me what the risks were. So what do you have? You have a question of fact. And when you have questions of fact, what does that mean? It means it's going to the jury. So if that's all you have a he said, she said scenario. You're the jury. I just told you the facts. Who do you believe? That's all you know. Who do you believe? The problem with that type of argument is that most jurors will believe the doctor. Why? Because they want to believe the doctor. They want to believe that these people who we put our lives and our trust into are going to do right by them. And they can't get over the fact that a doctor might do something wrong and not tell the patient about the fact that they could suffer these complications. If that's all you have when you're talking to the client, I suggest that you tell them it's not enough. You still need to be able to show that there were violations from the standard of care causing significant harm and injury. That's the only real way you can get a jury worked up and incensed about what horrible care and treatment they received. Because if all you're going with is just, hey, he didn't tell me I could suffer this, and the patient says, and the doctor says, yes, I did, you're going nowhere. Okay? So be aware of that. Those lack of informed consent cases on their own are usually not sufficient to go forward.